Hey guys, this is Lola, but you can call me Lola if you like.
Hi, this is Belisa, and you could call me Bells if you want. And
We had a webinar.
woo!
We had a webinar. We've been saying that we're going to have an employment law webinar, and we did it. We did it last week, and everyone's been asking for recording, and it's here. Firstly, a very special thank you to Nadine and Yasmine from Simmons, who co-hosted the webinar with us. They were our very special guests. We spoke about loads of different things, but I guess you can just listen to it.
Enjoy.
Bye. Okay, great. So just a little bit of housekeeping. We have an hour on the agenda today. We have some time for Q&A at the end. So if you do have a question, please put it in the Q&A. So there's a little button at the bottom there for you, Q&A, and we will go through those questions at the end. Hopefully we have time for all the questions. I think we should. We've thought about that. And in the meantime, I guess to sit back, relax. We are recording, and to be honest, we will share the recording. I can't tell you when we're going to share the recording, but we will share the recording at some point, and we'll let you know. We'll send an email out afterwards to tell you when the recording is available, and probably share the recording with you. And also at the end, we will be sharing some more information about Simmons. So as Nadine said, we're really doing top line now. So we only have an hour, so we're not going to be able to go into everything in detail, but there'll be an opportunity to sign up to information from Simmons, where you'll be able to get information from them directly, sign up to distribution lists and stuff like that. Nadine, do you want to give us a couple of bullet points of what we're going to be covering on the session, and then we can just jump straight into the first one?
Yeah, sure. So we've picked 4 kind of key topics to give you a bit of a whistle-stop tour on. So we're going to look at the legal meaning of biological sex and the fallout of the recent Supreme Court decision in relation to that. You may or may not have heard it being spoken about a lot, particularly in relation to the provision of toilets in workplaces and public spaces. So Yaz is going to cover that first. Then we're going to give you a little bit of a rundown of the key things to look out for the Employment Rights Bill that's currently working its way through Parliament. That's going to be a big legal change, probably the biggest we've had in employment law in England and Wales for over 10 years when that all starts happening. And that's looking like that's going to be happening at the beginning of 2026. Also going to have a little bit of a discussion about the EU AI Act and why you need to care about that. And similarly about pay transparency and what's going to be happening in the EU in the next couple of years and how that might impact things here in London and across the country as well.
Perfect. And what do you want to start with?
I will kick us off. So I'll start with discussing the recent Supreme Court decision for Women Scotland and the Scottish ministers. But before I do so, I'd like to start first by acknowledging that it is a sensitive topic, especially when it comes to the terminology that is used. So in order to accurately discuss the court's decision and its implications, I'll be using the terms as they appear in the Supreme Court's judgment. So I will use biological woman, biological man, or biological sex to refer to the sex assigned to individuals at birth. I will use the terms trans woman, trans man, or trans people to refer to people who identify with a gender different from their sex assigned at birth. And I will use the term certificated sex to refer to the sex attained by people who have been issued a gender recognition certificate. So turning now to the decision, as many of you have probably heard already, the Supreme Court ruled that the terms man, woman, and sex under the Equality Act refer to biological sex. What this means is a gender recognition certificate issued under the Gender Recognition Act 2004, which allows individuals to be recognised in their certificated sex, does not change a person's sex for the purposes of the Equality Act. So looking a bit more closely at what the Equality Act actually defines sex as, it says in relation to the protected characteristic of sex, a reference to a person who has a particular protected characteristic is a reference to a man or to a woman. A reference to persons who share a protected characteristic is a reference to persons of the same sex. So the Court of Session's earlier decision in this case determined that sex in the Equality Act could sometimes mean certificated sex, but in other instances it could only mean biological sex. When this got to the Supreme Court, they concluded that this was wrong, and they found that sex needed to mean the same thing throughout the Equality Act. And they reasoned that this is so that groups sharing a protected characteristic can be clearly and consistently identified in a practical way. In so doing, the court determined that the consistent meaning of the word sex for the purposes of the Equality Act must be its biological meaning, as they determined that an interpretation based on certificated sex would make core aspects of the Act incoherent and unworkable. The court also concluded that a biological sex interpretation does not disadvantage or remove protection from a trans person under the Equality Act, as trans people can still rely on the provisions regarding direct, indirect discrimination and harassment. So, for example, a trans woman could bring a direct discrimination claim on the basis that either she was discriminated against because of the protected characteristic of gender reassignment, she was discriminated against because she was perceived as a woman, or that she was treated less favorably because of her association with women. Indirect discrimination or harassment claims could also be made out on similar grounds. So that's a decision. So moving on to the implications of this, the primary concern among employers has been to assess the impact that this decision will have on workplace facilities. So first, it should be pointed out that the obligations on employers in relation to the provision of workplace facilities aren't actually governed by the Equality Act. It's governed by the Workplace Regulations 1992. So under these regulations, employers are required to provide suitable and sufficient toilets, washing and changing facilities as needed for men and women. Now, it says that toilets are only sufficient if they are provided for men and women separately or in separate self-contained rooms. Now, the regulations do not define the terms man or woman, and the Supreme Court's decision addressed the interpretation of sex specifically for the purposes of the Equality Act and not the regulations. However, based on the commentary and analysis on the decision so far, it seems likely that the Supreme Court's decision and its analysis will apply similarly in the workplace context. So most notably, many of you might have seen that the EHRC issued an interim update. And in that update, they made clear that in light of the Supreme Court's decision, sufficient single-sex facilities in the workplace refers to biological sex. They also state that trans people, however, should not be left without access to facilities. And so where possible, employers should provide mixed sex toilets, washing or changing facilities in addition to the sufficient single sex facilities. Now, I should flag for a second that the EHRC's interim update is not official guidance at this stage, and there has been challenge to the EHRC's interpretation of the Supreme Court's decision. The updated code of practice that the EHRC will publish on goods and services, which will have statutory force, is expected to be published towards the end of summer. So they're currently consulting on that now. The EHRC has said that the updated code will provide further clarity and authoritative guidance on the implications of the judgment for employers and service providers. So to briefly highlight a few other issues that employers will need to consider in light of the Supreme Court decision, these include their approach to data gathering, inequality reporting, access to internal networks, any positive action efforts under the Equality Act to improve the representation of women, and their family policies. So where does this all leave employers today? Well, employers should ensure that they do provide sufficient and suitable facilities for everybody, and they protect the rights of everybody within the workplace. So these include the right to privacy, the right to hold and express a protected belief, and the right not to be harassed within the workplace. Now, what compliance with all of these obligations will look like and how these rights will be balanced will vary for each organisation and will require detailed legal advice. So with that, I'll hand over back to Lola and Belisa.
Thank you very much, Yasmine. I think there's a lot there, right? So I think the most important thing for me is that what I've taken away is that you probably will need advice. It's good for us to understand the principles, but it's obviously a very sensitive subject. So I think it's one that employers definitely don't want to get wrong. And what I've taken away is, if in doubt, definitely get advice on it.
Yeah, and it's not one that's standing still, because already there's been an application to challenge that Supreme Court decision by way of judicial review, which is essentially kind of a different type of hearing, deciding whether or not that decision was made in the right way. So it's obviously something that people feel really passionate about, and something that different interest groups are going to continue to campaign on. So there's not going to be a decision and it's going to stay still for the next, 5, however many years. It's going to be something that both legal and HR professionals are going to have to keep up with and keep under review.
And it has practical implications. So it's hard when things are moving so much, because you want to be able to make decisions without thinking that you might have to, change that decision, especially when you're thinking about things like toilets. Like you need to create facilities, like those are it's very much capital expenditure. Like you need to build things or you need to move things around. So yeah, it's really, really tough one. Thanks, Yasmine. What do we have next on the agenda?
So I think next we can take a little bit of a look at the Employment Rights Bill, because it is still here. Like there were lots of headlines about it and lots of press coverage when Labour came into power. But the Employment Rights Bill, this big piece of legislation, it's working its way through the various houses of Parliament. Unlikely that anything's going to come into effect before the beginning of next year, but I say that, and next week someone will announce some groundbreaking thing because when the motivation is there, it happens, doesn't it? But be very surprised if there's any change in the law before January 2026. But let's see. So the key things on the agenda, the key things you need to account for. Firstly, unfair dismissal is expected to become effectively a day one right. So at the moment, an employer has to have at least 1 year and 51 weeks is the techie amount rather than 2 years of continuous service to be protected against unfair dismissal. So what that actually means is in order for a lawful termination to happen, it has to be for one of 5 specific reasons, which are redundancy, capability, conduct, illegality, or some other substantial reason. And the process that leads up to the termination of employment has to happen in a fair way based on the size and resources available to the employer. So if this comes into effect, that protection is essentially going to start from day dot, but there's going to be some flexibility during what is being called an initial period of employment, which is basically what we all call probation, right? So what the government is saying is there's going to be this immediate protection, but if you need to end someone's employment during the initial period of employment, which they're going to prescribe, and the kind of rumours that that's going to be anything up to 9 months, then there'll be a little bit more flexibility in terms of what an employer is expected to do in order for that termination to be lawful. So that's quite a game changer, right? Because at the moment, if anyone's under that magic 2-year mark, and particularly I know business managers love this when they're told this, if they don't know it already. It's like, well, yeah, if they're not doing what you need, let's do it now before we get anywhere closer to that anniversary, because then things get a lot more difficult. So that is all going to be out of the window. And at the moment, there's not much detail as to how much flex is going to be in this initial period of employment. So that could be quite significant in terms of day-to-day practice and how you manage your employee populations going forward. Another big one, and the reason why I think it's probably more significant than unfair dismissal is because it might catch businesses out. So changes in terms of employment and redundancies could potentially get a lot more expensive if things go wrong in the future. Now, the reason for that is because you probably saw a lot of press. I think it was the back end of last year. There was a lot of banding around of the term fire and rehire after the horrible situation the people that worked at P&O Ferries were put in. And basically they were just told bye, and a whole new swathe of people were brought in to do work. So fire and rehire is essentially kind of being banned if the current legislation comes to fruition in its current form. And why does that matter for you? It matters because when something like that happens, it falls into protection of legislation, which means that if an employer doesn't meet its collective consultation obligations, an employment tribunal can turn around and say, look, you didn't do what was needed here. You need to pay 90 days of pay to each employee that you failed to collectively consult with. And that bites when the proposal is to kind of change things for 20 or more people. So, in a redundancy situation, you very often hear about collective consultation obligations if there are going to be 20 or more proposed redundancies. But this particular bit of legislation, the definition of redundancy is much broader. So it can cover situations where, for example, your business might want to change some terms and conditions, and the easiest way to do that in their view is, all right, let's just get rid of these people, give them some new contracts to sign and crack on. So that's dangerous for two reasons. A, because it could trigger collective consultation obligations. And if that's not done correctly, the amount of award that is going to go up. So at the moment it's 90 days pay, and the government is proposing to increase that to 180 days pay per person. So that is not a cheap bill if you get that wrong. Secondly, fire and hire effectively being banned, there's a statutory code of practice that has to be followed. At the moment, actually, it's already live in terms of dismissing and re-engaging. And if that code of practice is not followed, then the Employment Tribunal can uplift compensation it awards to people. So you've got an increased protective award plus a potential 25% uplift if things go wrong. So it just makes this whole kind of field of what on the face of it might seem like kind of quite innocent changes, if you just need to like tweak some shift patterns or like need to kind of move some benefit situations around, but they happen to be covered in a contract. Really good, and it'll be really helpful to your business to have these points in mind so that you can flag them, because they very often don't get thought about, and it could be expensive if things go wrong. Kind of, well, next year onwards, really. So that's definitely something to have on your radar. The final one I wanted to cover, just because actually it's still in consultation period, so there's still an opportunity to kind of have a bit of input if it's of interest to you. So the Equality, Race and Disability Bill also came out of Labour coming in, and this whole employment rights bill. It's a long way behind the other changes, because at the moment a consultation is happening basically to decide whether or not they're going to move ahead with making pay gap reporting based on ethnicity and disability mandatory. So the proposal is to make it mandatory in the same way that gender pay gap reporting is for employers with more than 250 employees. And the consultation closes in a few weeks, and you can answer a few questions, you can answer no questions. It's open to businesses to respond to, individuals to respond to, whoever wants to, but it's really broad. So it covers literally questions from, I'm looking at it now, do you agree that large employers should have to report ethnicity pay gaps? Right through to more techie questions to, do you agree or disagree that public bodies should have to report on the difference between people of different ethnic groups by grade or salary? So if you have a view on it, if you want to see it happen, the consultation is there. And I think in this instance, there's really probably strength in numbers in the government, seeing that there is actual appetite within the population for this to go ahead. Because with the current climate, and this is my personal opinion, in my mind, any excuse to not do this will be grabbed hold of with two hands. So if we want to increase transparency and want to see something actually be legislated here, need to make sure that the government knows that it's wanted.
Thank you for that, Nadine. Just from my point of view as working with a lot of American managers, like the unfair dismissal from from day one, I think hopefully when it does kick in, it helps managers understand the importance of doing things right early on. I feel like there's always a massive cushion when people do find out, they do have 2 years. It's not a 2 years ticking time bomb to just get rid of someone without really, doing the work as a manager. So yeah, like all great stuff. And I would say as well that I hope managers get the guidance that they need when going through those different processes. And to your point as well, appetite in numbers on that last point, yes, because we don't want to have to complain internally when we could have done something about it, in the beginning. So appreciate that.
Yeah, and just on the consultation piece, I completely agree. It's hard because when I think about these things, it's like, why we already know, well, we suspect that there are some differences, some parity issues. I just can't think of why we wouldn't do it. But as you said, any reason not to do it, I'm sure will be taken. So yeah, if anybody is particularly interested, I am particularly interested, I think, engaging in consultation is really important. And I just think as a society, we actually don't. It feels like something that is really for businesses and for people who have, deep subject matter expertise. We think we kind of leave it for those people. And actually, for those HR people on the call, we actually do have subject matter expertise. But even as an individual person, you can be invested in something without feeling like you're not qualified to speak on it, because that's the whole point of consultation. So I encourage everybody to do that. Thank you. What do we have next?
Back to me.
I'm trying to look at my notes, but my screen is.
That's okay. It's back to me now. We're talking about AI. This is a hot topic, one that is very much likely to remain so. We see many employers rapidly integrating AI systems into their HR function in particular. So we see, for example, Workday or Bamboo, which many of you are probably familiar with, adding new AI features into these platforms continuously. So if your organization uses AI for HR purposes, and if you do have an EU presence, then you should know about the EU AI Act. So what is it? Well, it's an act aimed at governing AI systems across all 27 EU member states. The term AI system is broadly defined in the act. I'm not going to talk through the whole definition, but more likely than not, your HR process, if it is an AI, if it does use AI, it will fall into that definition. So who does the act apply to? It applies to 3 categories. So providers placing AI systems on the market or putting them into service within the EU. So those are, for example, Workday would be a provider, but employers could also be considered as providers if they deploy systems in their own name, or if they make substantial modifications to the AI systems that they use. The Act also applies to deployers of AI systems located within the EU, and this just means the organizations which are using the system. So they will be the deployers. But importantly, the Act also applies extraterritorially. So it will apply to both providers and deployers of AI systems that are located outside of the EU, where that output of the system is used within the EU. So in an employment context, if your organization has an EU presence and it uses an AI system anywhere else in the world, and the output of that AI system affects the workforce in the EU, your workforce within the EU, then you'll come under this Act. If you are subject to the Act, here are the 3 key things that I think you need to be thinking about as HR professionals. First question to ask yourself is, does your organization use an AI system for emotional recognition in the workplace? Now, what do I mean by emotional recognition? An emotional recognition system is defined as an AI system that identifies or infers emotions or intentions of individuals based on their biometric data. So an example of this could be the use of facial and speech recognition technology for the purposes of assessing an employee's suitability for a task, their satisfaction in their job role, or their productivity levels. Now, if you think you do use one of these systems, then you should take steps to quickly phase this out and should take legal advice in this respect, as this is now a prohibited AI system under the Act. Non-compliance with this could lead to very significant penalties, and this could be of up to 35 million euros or 7% of global turnover. So it's not insignificant. So it's definitely one to identify quickly if you think you do use it. Second question to ask yourself is, does your organization conduct training or learning about the usage and pitfalls of AI? So since February, the Act requires providers and deployers of all AI systems to take measures to ensure a sufficient level of AI literacy. Now, what is needed depends to some extent on the risk category of the AI system or each AI system that you use, but we would suggest that training is rolled out across the organization to ensure basic levels of literacy, and then you can adapt it as needed. Now, the key one is, does your organization use AI systems for recruitment, selection, or workplace decision-making? Examples of this could be if your organization uses AI to advertise job vacancies, screen applications, evaluate candidates, or in the workplace context, for promotions, terminations, performance monitoring, performance evaluation, any of those sorts of decisions. If you do use AI for any of these purposes, then these systems will be classified as high risk from August 2026. What does that mean? So the classification of high risk means that you, as a provider or a deployer of one of these systems, are then subject to extensive obligations. Now, the more onerous obligations are on providers, which more likely than not your employer will not be, but as deployers, you will also be subject to quite extensive obligations. These include things such as, and this is a non-exhaustive list, allocating properly qualified and competent human oversight, using relevant and sufficiently representative input data, maintaining records of logs generated by these systems, and complying with information and consultation obligations in respect of employee representatives and affected workers. Now, the first three obligations that I mentioned are particularly important from an employment perspective because discrimination risks are heightened with AI systems. These systems may be trained on biased data, which could then lead to unfair decision making. Now, if there is a discriminatory decision as a result of the output of an AI system, the employer and not the provider of that system is liable for any resulting discrimination. So, as we know, discrimination claims, if successfully brought, can lead to quite substantial awards because it's uncapped. So it's important that this risk is properly mitigated. Now, what does all of this mean for you as an HR professional today? Well, if your workplace is only UK based, then this does not really need to be high on your agenda right now because the UK legislation is still in the early stages of development. But if your organization does have an EU workforce, then you should really be thinking about this. But I do have some time before the full implementation of the Act, so the high risk portion comes into force next year. It's important now that you get a hold of what's going on in your organization. So you should understand and conduct risk assessments in respect of the AI systems that are being used in the HR and employment context. And in conducting these reviews, you should consider a few guiding principles. The first being transparency and explainability. Now, this is really important from an employment perspective. Can someone in your organization explain how that AI system works and the basis on which any decisions are made, including potentially as a witness in a discrimination case? So that's really important to consider there. Human oversight is another guiding principle. Is there human involvement in all the decisions which materially impact employment? Also, you should consider the impact on fundamental rights. So could there be bias in the system that might lead to a discriminatory outcome? So finally, on all of this, you should stay informed about how all of these are evolving because local laws in each of the EU member states might look a bit different. So you can subscribe to our fortnightly AI newsletter, which will be providing key updates in this area, and just try and keep a track of which how each jurisdiction which is relevant to your workforce is implementing this in the coming months. That's all from me on the EU AI Act. So I'll hand back over.
Thank you so much. I think this is such a big and important topic. Like, I love AI, but I definitely think that right now, if you sign up to any updates from any kind of HR information systems or ATSs, like everybody is introducing some sort of AI feature. And I think, and I work a lot with SaaS businesses, right, in the work that I do as a fractional HR lead. And most SaaS businesses are thinking about how can they introduce AI, because it kind of feels right now that if you don't have an AI feature, like what are you doing? Both in terms of optically and also in terms of actually AI can be great and can actually help your customer. So why are you not using it? So there's so many, I feel like we're just being bombarded with, oh, we have this new AI feature, we have that new AI feature. And I don't think now that, at least I can speak for myself, that I'm definitely in loads of ways not competent to say exactly how the AI works. And I think definitely as HR people and just as professionals in general, we often kind of say that's outsourced. Like, you know, if we get a question, somebody at the provider will be able to, you know, in the support team will be able to tell us how that works. But I don't think that, obviously, based on what you're saying, that we're going to be able to rely on that for very long. Like, we need to know. And I think even if, for me, even when I'm working with UK businesses, I definitely think we should start to think about this, because I don't know what the legislation will look like, but I think the understanding is also going to be really important. Like, how can we help ourselves to get ready? Definitely from a training perspective. Some businesses that I'm aware of, they are bringing in obviously lots more policies around using AI internally, doing a little bit more learning around like what AI is, but definitely in terms of, you know, the key people in the organization who need to understand how these things work, we should already be speaking to those people, even if we don't know exactly, even if we're just a UK company and we don't know exactly what the shape of it will look like. Either maybe we're going to expand, maybe we should just know, maybe we don't want to just do like the bare minimum.
Yeah. Or if you don't know, make sure whoever's negotiating that commercial agreement has got a really good indemnity in there in favor of your company, because when someone knocks on the door in 5 years' time saying, I think this product that you used actually had a discriminatory impact on me, so I'm suing you, company, because you decided to use this tool and it had this impact on me, you want to be making sure that that provider of the software that may have had this impact is paying out, and that the business you're working with or the business itself is not having to pay out for discriminatory act that it had no control over, other than it thought it was a good idea to put this product in place to help it be more efficient. It's going to be really interesting to see how this develops, like, over the next few
I
years.
definitely think like employees are becoming, as people, we're advocating for ourselves more. And I definitely think when it comes to AI, data, privacy in general, people are so much more interested. So I know that when we're bringing in new tools, or for instance, I had maybe like a year ago, was rolling out a new survey provider to do an engagement survey. And the organizations I work with, they have so many engineers. So like the engineers will literally go in and see what they can scrape to make sure that it's secure. Because they're like, if we can see any of the code and we can see it's not secure, then it was secure. But they will do that investigation. Like, people are so much more curious now. So I think gone are the days where we can just say, oh, we've introduced this and people are not really going to care. People are engaging in this topic so much more, which I think is a good thing. But we just need to make sure that we know the answers for ourselves first. I'm thinking about if it's even relevant to introduce these tools. Just because there's a new AI feature doesn't always mean you need to switch it on.
That's what I was just going to say. I feel like AI is like a wildfire. Like, if you don't contain it, it's just going to spread. And I don't know how much companies know that their employees are using AI at different levels. Like, you have some people who just want to write an email, so they'll use ChatGPT. And then you have other people who will use AI to literally create a fake background of what the office looks like in this country to sell it to an employee. So I think just trying to contain it is going to be one of the first things that people should do, is just contain it and find out exactly what is going on in your organization. Because if you don't know, you might think X is going on, but actually XYZ is going on. So yeah, it's very scary, and hate it or love it, AI is here to stay. So we just need to.
And procurement, and that's what I mean about having good policy in place, because depending on the kind of organization you work in, I've worked in big ones and small ones, the procurement process is like, it can literally be a manager signs this off and now it's bought and now we're implementing it. Or it could be that, I don't know, maybe you're in a bigger company where there's a policy and suppliers have to sign up to a code of conduct and all this other kind of stuff. But in some places, we just don't have the level of governance. So people can just be buying and using AI tools without actually consulting other people in the organization. So if we can be bringing this sort of information back to our companies and being like, hey, we need to consider this, I think it's wonderful. Thank you.
So it brings us very neatly onto the last topic for today, which is also about an EU piece of legislation. So if you are not having to deal with a workforce across Europe, you can relax a little bit and let some of the other information kind of just sink in that you've received in the past half an hour. But this will hopefully still be of interest to you, because whilst it's an EU-focused change, the potential kind of impact it's going to have on pay culture across the board is pretty huge. So what is it that's happening? Right, there's a big piece of legislation called the EU Pay Transparency Directive that is due to come into force in the summer of next year. It doesn't actually require reporting to kick in until 2027. And that all sounds like a long way away, but as we all know, right, business as usual just takes over, time flies. You wake up 2 quarters have passed, it's the end of the year, what's going on? So the reason why we're talking about this now is because it's changing things pretty substantively across the EU, and it's going to require 3 key things. Reporting, enhanced information rights for employees, and a prohibition on asking job applicants about current or historic pay. So of relevance, even if you don't have an EMEA workforce, because let's say, like, we all work in teams. I mean, Yaz and I ourselves work in a team whereby, like, yes, we have our London based, but we've got colleagues in Paris, in Madrid, in various parts of the Netherlands, in various parts of Germany, and we are all interacting with each other on a day-to-day basis, right? Very often working with each other on cross-border projects. So, like, if you're having a chat with your buddy in Madrid and they're like, oh, we just got told this, blah, blah, this is coming in. Now we get all this information about salaries, and I'm here in London. I'm like, interesting. Why am I not getting that? Like, it just opens the doors to discussion. So it's going to be really interesting to see how employers deal with this. So what exactly is coming in? There are lots of different requirements. I'm just going to give you a rundown of kind of like 4 of them. But I think in terms of what you need to be talking to stakeholders about within your organization or other members of your HR team, A, do they know that this is happening? B, has anyone done any groundwork on what it means and how it could be implemented in the different parts of Europe that you might have a presence? And C, how are you going to deal with this? Are you going to deal with it on an office by office basis, depending on exactly what the local law requirements are? Or do you want to have a global approach so that kind of everyone has the same rights? And if you do that, are you going to include people who are in scope of the law, or are you going to exclude them? Lots of different decisions to make, I guess more from a kind of company culture perspective, not just strict legal ones. But on the legal side, what is this directive going to mean? So it's going to provide pay transparency for job seekers. So basically, there's going to be no more debate about whether to include information about pay in job ads. It's going to be a legal requirement in the EU member states that this directive applies to. People are going to have a right to information about pay levels of colleagues and pay for new roles they might want to apply for. So, for example, when people are going for an internal promotion, they will have a right to know at the outset what the pay for that is. Pay levels of colleagues, there's not too much detail as to exactly what that means and whether it's something that people can request if they are concerned about something, or whether they can just ask for, or whether it will have to be published. But that's going to be interesting because, well, you can imagine, right? You've got a team of people that can basically not even have to ask someone, they can see what X is being paid. Like, yeah, there's going to be some fascinating discussions triggered by that. The new law also requires publication of pay information based on roles that are jobs that are the same or of equal value. So it's quite similar to something you may have come across in this jurisdiction when there are equal pay discussions or equal pay disputes. So like in a lot of the supermarkets, there are ongoing cases still where people in roles that are carried out mostly by women have not been paid as much by roles that are deemed to be of equal value of men. And there's been lots of payouts in councils as well in relation to that. So this is kind of like a version of that, but to make sure, again, there's transparency as to whether like work or the same work is being paid for the same to all people. So there are differences in how each of the member states are going to implement that. But if you're in an organization where you haven't really had to think about this before, so you haven't had to think whether James in accounts is doing work that is similar or the same as like Robin in, I don't know, account analyst, I don't know, I'm making up departments, right? But someone needs to kind of step back and look at all the different roles within the organization and work out what should be considered the same under the law, what should be considered similar. And organizations are starting to actually do kind of dummy audits so that they can understand themselves whether there are any potential issues with the data that they're going to have to report in the coming years, with a view to kind of taking proactive steps now to address them. Because once the information is out there, it's out there, right? And it's very difficult to then take it back, particularly if it highlights things that you know that your workforce aren't going to be very happy about, or worst case, if it identifies anything that is a real legal risk. And the 4th thing this directive is going to do is to require gender pay gap reporting, quite similar to what we do in this country now, but a little bit more enhanced. But that is new in some EU countries because gender pay gap reporting isn't a given across the EU. So that's a big thing in those areas. Who within your business needs to start thinking about this now? Lots of different elements. So I would suggest obviously HR and legal, comp if there's a comp team, payroll, and actually probably kind of key decision makers within different functions of the business, because when they're considering now and they're projecting for hires that they're going to need next year, the year after, and they're looking at budget and looking at kind of salary allocation, they need to be aware that this directive is coming into place, because the decisions that are being made now are going to impact that data that has to be reported in the coming years. And probably comms, actually, because we probably all have stories or have seen situations where communication has gone wrong. So even when a company or an organization or people, right, have done things in the correct way, follow correct procedure, if the comms aren't on point and the comms go wrong, all of that hard work just gets washed away. So it's really important to kind of think ahead of time now, okay, A, is this something we even want to bring to our employees' attention, or actually we're going to wait and see if we get any questions about it? B, if we're going to do the latter, what are we going to say if and when we do get inquiries? Do we want to have an FAQ document? Do we want to have like a town hall? You know, all of those kind of considerations. And it may be that it happens, no one even asks any questions about it initially, but there will be a point where it gets quite high on the radar, because if there's one thing that people care about at work, it's money. So it's going to come up. So that is a very, very quick rundown of EU pay transparency and what that's going to mean. Some very wonderful colleagues of mine are doing a webinar on that actually on the 11th of June. So if it is an area that's of particular interest to you, definitely worth signing up for that. But you'll be able to find all of the information via the QR code that's going to be shared with you once we've wrapped up and dealt with questions this afternoon. But that is the EU Pay Transparency Directive, everyone.
Thank you. Thank you for that. I'm so interested in this just because, so anyone who listens to the pod knows that I've worked in big tech companies for the last like 7 years. So that's already pretty much the norm to know other people's salary or to have those conversations. So what you said, Nadine, about the culture in companies playing a part and a role in it as well is going to be important, is definitely something I agree with, because even if people have to do it based on them having sites in EU countries, how they do it is going to be based on the culture. It could still be very, you know, very quiet. You know, the comms could be very quiet. Whereas if it's a company that believes that, you know, they do everything they're supposed to and ethically they want to do everything right, they might be a bit louder about it. They might do focus groups. They might encourage the conversations. So I do think culturally it's going to be very interesting to see how different companies navigate, you know, launching that out.
Yeah, I'm just thinking when we saw it in the States, in the US, some companies maybe they weren't so like honest with how they did it. So we saw companies publishing salaries which had like super wide pay bands when they were saying like, oh yeah, you could be paid anything from $80,000 to $180,000 or something. And obviously there was some pushback on that, and a lot of that has been addressed now. But it'll be very interesting to see how it happens, because that's, for me, is the frame of reference that I have is when they did it in the US. But if you're going to compare the culture, for instance, in somewhere in the US to, for instance, in the Netherlands, like it's very different, even in how people communicate and how, you know, the underlying kind of employment rights that, or the labor law that employees have. So I'm really interested. I'm just hoping that, you know, where it applies with organizations that have like an EU workforce, like it doesn't just create absolute chaos. I think it's good to have pay transparency, but I'm just thinking like if you give people, one day people don't have access to information, the other day people do have access to information, then it could go a bit left if it's not managed correctly, which is really important, which is why it's really important for us to do the comms and the management of it very well. Perfect. So we have 10 minutes left, and I want to open up to do some Q&A. I see some questions coming in. We have a couple of comments actually, as well as questions in response to the stuff we said around the consultation for the ethnicity pay gap. Someone said, I'm not in HR, but I'm completing the consultation now. So that's great.
Thank you.
We also had somebody comment around the stuff to do with AI, that their company banned all AI except for Copilot 3 days ago. So
That's
I mean,
not surprising. I think
that's one way to
a
do
lot
it.
a lot of people are using it. I think a lot of employers are finding that people are using it, as Melissa touched on earlier, in ways that they're just not aware of. So until you can ring fence it yourself and I guess police it, I guess an interim measure that makes sense is just to stop access altogether until you can then put across those safe barriers.
I think we're going to see lots of, because we're going to probably see more companies saying that you can't use AI, and especially like ChatGPT and stuff like that, I think we're going to see so much more ER in relation to it, because I think some people have become so reliant on using AI in their work that it's going to be difficult for them to do it. And we're going to see employees doing it in a more covert way, which is obviously against policy. And that'll be Lisa's problem. I think in relation to the hire and refire stuff that you was talking about, someone has asked, does this apply to rehiring as a contractor or rehiring someone as a self-employed person, etc.? So could you fire someone and re-engage them as a self-employed person? I think that's the question.
Yeah, or I think so. It comes like I think it's a question about employee status, right? So remember, just because someone has a contract that says that they're a contractor or says that they're self-employed, doesn't necessarily mean that the law will see them in that way. So, like, it applies to employees, but the caveat to that is someone could be on a consultancy agreement, but actually, if they ever contest that, in the eyes of the law, they could be seen as an employee, so it could apply to them. So simple answer, no, doesn't apply to contractors, doesn't apply to people who are self-employed. Legal Nadine answer is, the caveat to that is, don't forget that sometimes people are engaged on incorrect contractual terms, and what's on paper doesn't override what happens as a matter of fact if that person ever decides to say, actually, even though I've been benefiting from this consultancy agreement for the past 10 years, I actually think I was an employee at that time, and now I want my back pay and holiday pay and pension contributions and everything else.
Perfect. Another question on pay transparency. Someone said, is this dependent on the company size? And then they wrote, sorry if I missed this.
The gender pay gap part is, so the gender pay gap part is for companies with at least 250 employees. The transparency and right for information part, I don't believe so. I can't give you a definitive answer. I'll have to check the number, but I know that the pay gap, gender pay gap part definitely is. I'll check on the transparency and the right to information bit. So if you want to leave your details, or if we know who that person is, then happy to provide an answer on that offline.
Somebody said, where can we find further resources on AI in HR and the EU AI Act?
On our website. Shameless plug, shameless plug. But yeah, there'll be a QR code at the end which will show links to our website. We have comprehensive pages, like really detailed pages about what you need to know. Then we also have higher level pages and links to sign up to newsletters where we there it is, where we circulate fortnightly updates on this, so you can keep informed there.
And there are also some really good free webinars, which the team that specialises in this have put together. So it literally takes you through everything from, and probably a good resource to share within your organisation for people that need it. It takes you everything from what Yasmine so fantastically explained as to what is the EU AI Act, what is a deployer, what is a provider, does it still apply to me if I'm not in the EU, covers topics like that. And they're just like really nice, short, snappy, kind of ingest the information rather than having to read it. So recommend those as well.
Perfect. Someone said, how do you complete the consultation, please? And this is just relevant to the ethnicity pay gap stuff we spoke about.
It's online. It should hopefully come up with a quick Google. I know it's on the gov.uk website. Don't have an exact link to it, but hopefully if you Google the two, it will come up pretty swiftly. But it's definitely still there because I was looking at it this morning.
Someone said, we've had our work.
Someone's put the link, so I'll just put it in the chat, whoever did that. Yeah, for the last question.
Perfect. So somebody said, it's more of a comment, we've had our, I think that's work codes, maybe like ERGs, workers communities, asking for the suspension of data collected through AI. So just something that's happening internally.
That's interesting. So the workforce have actually said, we don't want you doing this.
I haven't seen that yet, but I'm not surprised because people are so much more invested and interested than I've ever seen before in this particular subject around AI, data, privacy, all of that stuff. Oh, work councils. There we go. That's what work code stands for. And we've had a couple of other comments. How are we doing on time? Okay. Somebody said, I don't work in HR, but I'm interested in the EU Pay Transparency Directive. I'm a former finance lawyer and now do financial education workshops. I usually have to be careful when talking about negotiating pay based on what you know about your colleagues. Based on what you know about what your colleagues are earning because of pay confidentiality clauses. Are we still allowed to have pay confidentiality clauses?
No, I was going to say, so that even though no one ever relies on this or kind of points it out to their employers, but you can't have pay secrecy. And if an employer tries to enforce that here, like you're breaching legislation. So and all
Is
of
that
us,
in the UK or EU? Or...
yeah, no, in the UK. So anyone as an employee in the UK, I can't, like, no, my employer can't stop me from saying to Yaz, like, how much are you earning? Like, what do you get for this? And, you know, if Yaz decides to tell me, nothing anyone can do about that, or nothing anyone should be doing about that. But people don't do it. It goes to the culture point, right? And I find that to be a very British thing as well. Like, people don't talk about money. And actually, in my view, that's to the detriment of particular categories of people, which just is still standing. Like, people are so concerned about it, but like legally, no one can stop you.
I think a lot of it is about the power imbalance, because even if people knew that it wasn't necessarily legal for the employer to ask them not to discuss it, you still want to stay in the good graces of your employer. And if you're doing things which could, quote unquote, create disruption in the team, you might think that that will reflect poorly upon you. So I think it's really hard, because even if people know that they can do it, it doesn't necessarily mean that they will, because of the kind of power dynamics in the workplace and how that works. I think those are all of the questions that we have time to answer for now. If there are any other questions that you have, I mean, you can always send them through to the podcast. We accept questions and comments and everything on our website. We have our Instagram, our TikTok, our YouTube. If you haven't watched the podcast, if you're new to the podcast and this is the first time you're finding out about us, please watch it. I think it is probably the best HR podcast you will ever listen to. What have we got like on Spotify, like 4.9, and the 0.1 is Bad Vibes People. So that's that's our plug. As I said, please scan this QR code that's on the screen now. That will give you all the information you need from Simmons and Simmons, how to get onto their mailing list, more in-depth information on all the things that they've said today. And just all that remains is for me to say thank you so much to Yasmine and Nadine. Really appreciate you coming on, and it's been a very informative session.
Thank you.
Our
So much.
pleasure. Thank you for having us, and everyone have really great afternoons and happy weekend. Nearly there.
Most.
Perfect. Thank you, guys.
Bye.
Bye.